All right, good evening. My name is Daniel Morrissey. I'm the chairman of the Zoning Board of Appeals in Springfield. I'm calling this meeting to order. Just a brief introduction. This meeting is being held pursuant to the open meeting laws of the Commonwealth of Massachusetts. We are obviously modifying or complying with the open meeting laws given the COVID situation. So this meeting is being used with Zoom. In order to comply, the notice has been sent to abutters, and anyone from the public is allowed to speak. We will hear tonight from the petitioner and anyone in opposition, and then we'll allow a week for anyone else to speak out or write in from the public, and then reconvene a week from tonight for deliberations, which will also be done via open door, so to say. We'll do it via Zoom, and anyone can tune in to our deliberations. As I said, I'm Chairman Daniel Morrissey. And tonight we also have with us Mr. Norman Roldan. We have Mr. Eddie Corbin, also Mr. Walter Gould. I believe we also have a code inspector, Michael Yakum, and we have our board secretary, Vanessa Adorno. Once Mr. Bruce has joined us, I'll also introduce him. We have two petitions on for tonight. Please make sure that if you're going to be speaking tonight that you have, I know you can't physically sign in, but that you've let the board secretary know ahead of time when you are asked to come forward and to speak. I will ask you to state your name and address for the record and also be sworn in. We also have very strict jurisdiction in terms of, I shouldn't say very strict, we have strict jurisdiction for the hearing. So I will read that verbatim. In order for a variance to be granted, the petitioner will have to show, number one, that owing to circumstances relating to soil condition, shape, or topography of land or structures, and especially affecting generally the zoning district in which it is located, a literal enforcement of the provisions of the ordinance would involve substantial hardship, financial or otherwise, to the petitioner. Two, that desirable relief may be granted without substantial detriment to the public good. Three, that granting such relief would not nullify nor substantially derogate from the intent or purpose of such ordinance or bylaw. Please keep these three requirements in mind as our jurisdiction is limited to them. In terms of process, we will first hear from the petitioner in any given matter, and then we will allow for anyone else in favor of the petition to speak. Then we will allow for anyone in opposition to speak. And then if there is indeed opposition, we'll allow the petitioner 10 minutes of rebuttal time. Depending, of course, on how many people from the public we have speaking, from time to time, we do limit testimony that may be repetitive we'll set that as we'll play that by ear. Sometimes we might limit testimony. I don't know if that's going to be the case tonight or not.
No.
Please make sure while you are, if you're not, besides board members, if you're not speaking, so for instance, if the petitioner is speaking, if everyone else could please mute, just like we would if we were in the actual room in City Hall. We ask that people silence their cell phones, so on and so forth. If you could please mute your phone or your Zoom, that way we don't get any, back conversations or interruptions, and we can hear clearly. Also, these proceedings are tape recorded, so please kindly speak clearly, slowly, and loud enough so that we can have a clear record in case there is an appeal or if we have to visit the record again for some reason. That's very, very helpful. Please keep that in mind. Is that Mr. Bruce?
Yes.
Good evening. That's Mr. George Bruce. I'd like to introduce him as another member. So we now have 5 members to hear tonight's matters. Mr. Bruce, all I did was just gave the introduction. So we're about to start. And we're going to start tonight with the first petition being Mr. King.
Yes.
And that's 9799 Norfolk, East South Norfolk Street.
Yes.
East side,
Hi.
Norfolk.
East side. Sorry about that. How you doing, Mr. King?
I'm doing fine.
Good. Would you mind please stating your full name and address for the record?
It's Freddie L. King Jr., and I live at 17 Sunbright Road, Springfield, Mass. 01129.
Thank you. Would you kindly raise your right hand? Is that the? Yeah, I didn't know if it was like a mirror image or not. Thank you. Okay. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Thank you very much. Just before you start, Mr. King, just for the people in the audience, if you kindly, just those that are waiting the second matter, I don't know how long Mr. King's matter will take. I wouldn't want to say that you should tune off, sign out of Zoom, because I don't want you to necessarily miss anything if you're waiting for the second matter to be heard. But it may be 10 minutes, it might be a half hour. I have no clue how long it will take. If you do, though, if you could mute your phone, and also if you need to do something, multitask, whatever it is, that's fine. Just if you would pay attention for when the second matter begins.
Okay.
Okay. So, Mr. King, let's hear from you. Go ahead.
Well, I applied for a variance about a year ago, and I got approved, and I didn't move on it, I guess, in enough time to get an extension done on it. So this is the reason why I'm doing it over again, because I have another potential buyer that's ready to move on the property right now, but they want me to get the variance done before I sell it.
Right. Okay. So can you tell us why you think that the board should grant the variance?
I mean, it'll be beneficial for the community and for me, because I could use the money. I've been paying on this property for a long time, and I had a lot of interest in it as far as right now.
When did you purchase the property?
I want to say probably in 05. I'm not for sure. I have to look on the deed, but I owned it for about 10, 15 years.
Did you purchase it as an investment property or as a primary residence?
No. Well, I used to live right next door to the property, and my mom bought it. And when my mother moved out the house next door, I just ended up keeping the property just to have. But I was planning on doing something with it myself, but I didn't have the financial money at the time.
Okay. And what was the reason you said you had initially applied before us, but then it was the variance originally it was granted or not?
Yeah, it was granted, and I had a buyer that wanted to buy it, but we couldn't agree on the price. So that's the only reason why. After I got the variance, if I'd have known, I would try to do something with it myself. I didn't know that it expired. I thought it just, once you got a variance, it stayed open or whatever. So now I got a buyer right now on the hook that wants to buy it. They just waiting for me to get the variance done for it.
Okay. So you're saying this very board, the Zoning Board of Appeals, did grant your variance about a year or so ago? I think you're frozen. Mr. King? Let's just give him a...
Very lost.
All right, let's wait a moment. Mr. King? Let's give him about, we'll stay on the record. Let's give him about 30 seconds to a minute just to see if he can come back so we don't lose him. If not, we can move on to the next petition and come back to his.
Well, I can just say that I know it was granted. I think he's a little off on timing, but it was definitely granted.
It was granted November 7th, 2018.
There you go.
Right,
Okay.
right.
Oh, so he waited the required 2 years to come back before us.
Yep.
Okay.
Correct.
Does anyone recall what the planning recommendations were a couple of years ago?
I got them here, Mr. Chairman.
Is that the one that I'm looking at? No, I'm looking at it from April 6, 2021, but from 2018.
2018, I have in front of me.
Oh, you do? Walter?
Yeah, the planning department denied the petition.
Right.
Oh, he was in front of planning, but what about our? Oh, I see. They were not supporting it. Okay, I understand.
Right.
So the body
Okay.
must voted yes.
Okay. Do we have Mr. King back? Mr. King? All right. Let's give it just one more minute, just to,
Well, he did, just for the record, he bought the property in 2001.
okay. Vanessa? Vanessa,
Yep, I'm here.
do you have his cell phone number?
Oh, he's back. I can
Oh,
see him.
great. You see
It might
Mr.
be a little
King?
spotty, but he's back.
Okay,
Hang on,
Mr.
he's
King?
still muted. Let me ask him to unmute.
okay.
Can you hear me?
Yes, Mr.
King?
King, how you doing?
Fine. How you doing?
All right, good. Yeah, we waited for you to get back on. Are you like in a stable, it's a good spot to speak now in terms of your service?
Oh,
Your
yeah,
signal?
my phone, it said got hot. The phone got hot. I don't know why, though, but.
Zoom does that.
Yeah.
Oh, Zoom does that?
Yeah.
Yeah, it
All
does.
right.
Okay, so here we are, Mr. King. If you want to continue, what we were, my last question was whether, and I think we have that answer already, but if you would like to answer the question, was when you were before this board last time, you're saying that this board granted your variance request back in about 2018?
Yes, they did.
Okay. So I know you said there was some financial hardship on your part. Can you just elaborate on that a little bit more? I know that you would be able to make money off of a sale of a multifamily home, but what has been the hardship that led to this? What, have you invested money in the property to get it to convert it into a 2-family? Like, can you address that?
Well, I just been maintaining the property, keeping the landscape up, and paying the taxes, and just staying on top of the bills and stuff for the property.
Was anybody living there between? Go ahead.
It's an empty lot. It's not a building or nothing there now. It's just an empty lot.
You're gonna construct from now. Okay, so it's already right. Okay, you're constructing. Okay.
Yeah. It used to be a 6 apartment building, and they tore it down, and I just owned it ever since. It's just been an empty lot.
Did you purchase that like from the city as some part of, when the city auctions off properties that are dilapidated or, eyesores or anything like that? Was it part of some type of project or program like that with the city when you originally purchased it?
Now I know my mom, she just inquired about it because we live next door, and that's how she ended up getting the property.
Okay.
Mr. Chairman, can I just ask
So
a question?
Go ahead, Mr. King, and then we have a question for Mr. Gould. Mr. King, go ahead if you want to finish what you're saying.
Oh yeah, I forgot what I was saying. Yeah, it was just a building there, and it was an empty one. Like I bought it. I ended up getting it from my mom before she moved.
Okay.
Like I said, I grew up next door to the property all my life. I lived there my whole life.
I understand. Okay. Mr. Gould, do you have a question?
Mr. King, I just wondered, since we don't have a building plan in front of us, I was wondering, is this going to be a side-by-side, or is this going to be a 2-family up and down, or do you know?
I was thinking they probably would do a side-by-side or a conventional. I'm not for sure, but I know that the contractor say he could go by whatever rules I guess the city of Springfield need.
And I think I asked this the last time you came before us. The parking, Mike, I think you said the parking they'd have to have at least parking off street for 2 cars. I believe you said 3 years ago.
Well, if he's doing a family, more than likely it's going to be 4 or 3.
Uh-huh.
I think it depends on the bedrooms.
Okay.
Now, Mr. King, you just said possibly side by side, possibly up and down, vertical. For the planning recommendations, what we're seeing is that there is a mixture of 2-family and single-family homes. Of the 2-family homes in that immediate neighborhood, are they mostly side by side or up and down, or?
It's a few up and down, and recently a few people just built a couple side by sides down the street.
Okay.
Mr. Chairman, Walter Glows, he's right. I was up there Saturday morning, and he's right. There's a new one going up that's, I believe, up and down, and there's a couple side-by-side ones on streets around it.
Okay.
So it's kind of a mix, like the planning board said 3 years ago.
Thank you, Mr. Golden. And Mr. King, so you're saying you currently have a buyer? Are you under agreement?
I am. I do have a contract with somebody right now.
An offer to purchase or a purchase and sale agreement, or?
Yeah, y'all got. I think it's in those paperwork. I think it's I submitted with the paperwork. I think it's Mass Housing Corp. They're interested in buying it.
Yeah, I saw that document.
Yeah. Oh,
Yeah, I saw that.
Yeah.
Yeah.
Mr. King, how do you think this property is sort of different? Like, if we were to grant this, what would make us not have to grant anybody who sort of came and asked for a similar variance? What's different about this? How does this fit into the neighborhood in a special way?
I think it would benefit the neighborhood instead of just having empty lots there as a sore eye, and people dumping stuff and all that.
Okay.
And so you maintained
like
it sort of
keep
just
it
like,
maintained. So
yeah. Okay. Have you
keeping the grass cut and keeping the trash and debris off?
Okay. Have you reached out to any? Sorry, I know Mr. Gould, you normally ask this. I don't mean to jump the gun and take this question from you. Have you reached out to any of the neighborhood groups or gotten any immediate, abutting neighbors or anything like that to sign a petition or anything in support of you?
No, I haven't, but I know the person that lives right across from the property I own, they have like a lot the same size. They want to do the same thing I want to do. They want to get a variance done for their property so they can build a 2-family or something right there.
Okay.
So I don't think nobody would be against it because, I mean, like I said, I grew up in the neighborhood. I mainly know everybody over there.
Mr. Chairman?
Okay. Yes, Mr. Roldan?
Yeah, and along with Walter, I drove up that way and I pass there once in a while. I go by there. All those lots are almost all the same.
Okay.
And Walter could attest to that they're not set up in any form. So, they're all different types of form of the houses. So
Okay.
this lot aligns to what they're doing currently today.
And it looks like he's only, 266 feet off in terms of the square footage?
Yeah.
18.
Yeah. Okay.
18, so.
Mr. King, do you have anything else that you'd like to add in support of your request?
Not offhand.
Do any board members have any more questions for Mr. King?
I have none.
Mike, Mr. Yakum, do you have anything worth you think clarifying or adding to?
Well, no, I mean, just for clarification, in the new book, you would need 3 parking spaces for a 2-family.
But that's not before. I mean, that wouldn't even be a condition if we were inclined to grant this. That's not something that we.
Yeah, no, he would have to provide the parking even if it was 4.
Okay. But that's not before this board, correct?
No, it's.
Okay. Well, I appreciate that. Anyone else have any questions for Mr. King?
No. Mine was
Okay.
on parking.
Thank you very much, Mr. King. Is there anybody else that would like to speak in favor of this petition? Is there anybody else that would, is that somebody? Anybody else that would like to speak in favor of the petition? Make sure you're unmuted. I don't hear anybody. Oh. Okay. Is there anybody that would like to speak in opposition? Is there anybody that would like to speak in opposition? Make sure you're unmuted. No, I don't hear anybody or see anybody. Okay. All right, Mr. King, thank you very much for the testimony you gave. We also have written submission. We have the planning recommendations. So just so you know, it's a little bit different than when we were in person. 1 week from tonight at the same time, 6 p.m., we will reconvene on this matter and we'll deliberate, regarding your request on Zoom, on the same type of Zoom call in front of you. So if there's anything else that you want to submit, or if you know anyone that would like to submit anything in favor of this petition, they would need to do so between now and next Wednesday, if they'd like it to be considered for purposes of our decision, okay?
195. Okay.
All right, thank you very much. Have a good night. You can sign out if you'd like. Just make sure there's no decision rendered yet. So please don't begin any construction, anything like that. We need to still deliberate and make a decision, all right?
Okay.
All right, thank you very much. Have a great night.
Yeah, thank you.
All right, you take care. Okay. So does anybody need anyone need a break or anything like that, or we can go right into the next matter, correct?
Yeah.
All right, perfect.
Agreed.
So what's that? All right.
Agreed.
Agreed. De acuerdo. Okay. One moment, please. So for our second petition, we have the Springfield City Council, represented by Attorney Epka. Mr. Epka, Attorney Epka?
Yes. Thank you,
Great. Do you
Mr.
have your
Chair.
video on?
Yes.
All right, there's one more. If I can. One moment. See if I can see you.
Is it helpful if I talk and try to get my video to pop up here?
Oh, I see you. That's great. I got you. Okay, Mr. Epka, would you kindly just tell us state your full name and address for the record?
Yes, my name is Johannes Epke. My address is 62 Summer Street, Boston, 02110.
Great. You're a member of the Massachusetts Bar, correct?
I am not actually. I'm a member
Oh,
of the
I'm
California
sorry.
Bar.
You applied Pro Hoc, the California Bar, correct?
Yes, correct.
Okay, that's great. So I don't have to swear you in. So Mr. Epka, if you'd like to present. So just, I want to restate this. We will hear from you, Mr. Epka, as representing the city council. Then we'll hear from anybody else who is in support of this petition, then anyone who's opposed, and then you'll have 10 minutes for rebuttal time. In terms of speaker time, my understanding is that you'll be speaking on behalf of the petitioner, and there might be possibly two city councilors, I believe, or a couple city councilors who might be able to add or make themselves available if there's any additional questions that the board has that you might not be able to address.
That's correct.
Okay. All right, that's great. So go ahead, please. Let's hear from you.
Great. So first, thank you, Mr. Chair, and good evening to the board. Appreciate the opportunity to speak. As I said, I'm Johannes Epke. I'm a lawyer with the Conservation Law Foundation based in Massachusetts, here representing the Springfield City Council in this matter pro bono. Conservation Law Foundation is a not-for-profit organization that uses law, science, and the market to preserve natural resources, build healthy communities, and sustain a vibrant economy. The issue that I'm here asking you to rule on tonight is a little bit different. It's not a variance. We're asking you to declare that a permit issued to Palmer Renewable Energy in 2011 has since expired and is therefore invalid. So just to ground your authority and the source of this, the Springfield zoning ordinance, section 11.2.11, grants this body the authority to hear this kind of appeal on failure to enforce. The section there is, an appeal to the Zoning Board of Appeals may be taken by any person aggrieved by reason of his inability to obtain a permit or enforcement action from an administrative office under the provisions of this ordinance. So that failure to obtain enforcement is the Springfield City Council, or the Springfield Zoning Enforcement Officer's decision in his letter to the Springfield City Council, February 23rd, 2021. So to back up a little bit, a brief overview of the facts and issue at hand. As I said, Palmer Renewable Energy was granted permits for initial phases of construction on a power plant on November 15th, 2011. These initial phases include some site grading for stormwater system and a pouring of a concrete foundation for the power plant stack. The Springfield City Council originally challenged these permits on the question of whether or not the facility should be categorized as an incinerator and thus need a special permit. This body agreed with that appeal and revoked the permits in 2012, but courts later overturned that and reinstated the permit, and so we're back.
Attorney Epka?
Yeah, of course.
Could you hold on one moment? If anyone besides Attorney Epka right now, if you would kindly mute your Zoom, just there's some background noise that makes it difficult. to hear. And if you'd like to, if you need to chime in at some point, if something's urgent or if one of the board members has a question when he's finished, we can unmute at that point. Okay, go ahead, Attorney Epka. I apologize.
No problem. Thank you very much, Mr. Chair. So the challenge now before you is on these permits is for failure to act on them within the time window allowed. So a condition of these permits issued in 2011, the condition stemming from the state building code is that construction has to commence within 180 days of issuance of that permit. We're now approaching 10 years since issuance of the permit, and Palmer has still yet to commence construction. And so we're asking you to declare that these permits are lapsed and invalid, and that construction cannot commence without issuance of a new permit. So Palmer Renewable will argue that they have indeed commenced construction, and additionally that this 6-month period to commence construction is still in effect, that it has been tolled for nearly a decade now because of the effect of the previous appeal on the permits, the tolling of that litigation, and an extension of the window granted by the legislature in the Permit Extension Act of 2012. So I'm going to explain first why that permit period has run, why it is now lapsed and closed, and conclude by explaining why Palmer did not meet the standard of commencing construction necessary for the law. And then once I've established those two pieces, putting them together is pretty simple. If they didn't start construction and the period to start construction has closed, they no longer have a valid permit and therefore can't start construction at this point. Just before I dive into the facts on the timeline and the standard for commencing construction, I just also want to note that this is from a policy perspective of a very natural outcome that you declare this permit invalid. As I said, this was originally meant to be a 6-month permit, a permit to start construction within 6 months. We're now approaching a decade later. You know, that's a 2,000% increase on their permit period. They would have had to come back 20 times to get extensions over and over if they weren't trying to toll it by litigation and so forth. And so the reason for that short timeline is well served by you declaring these permits invalid. So first on the timeline, as I mentioned, the state building code requires that all building permits require construction to start within 180 days. So these permits were issued in November of 2011 and would have originally expired in April of 2012 had they not been tolled. And so even if we assume a pretty generous interpretation of the timeline, the 6-month period has long since lapsed. And I think it makes most sense to just walk you through the chronology, the series of events that get us to where we are. And one helpful way to do that, Palmer Renewable Energy very generously included a timeline in their response. And so if you want to walk with me through that.
Is this the timeline?
That's correct. It should be the first appendix.
If we could just pause for one moment. Attorney Epka is going to go through this timeline. This is in the submission by Palmer Paving. If anyone on the board would like to take a moment, if you have this, to pull it out, it is helpful. And I believe it's also very, I was actually, Attorney Epka, you took the words out of my mouth or the question out of my mouth. I was going to ask if you could use this as a guide as you go through. So any board member, just take a moment, give you a few seconds to pull this out. If you could, it'll be really helpful.
Great. Thank you, Mr. Chair.
Just give people a second if we could.
Of course.
It's just, if anyone's looking for it, it is in the submission by Palmer Paving. It's right after the argument. One thing that would be helpful in the future, I know it's not required by our board, but like a global pagination would have been awesome for these submissions. You know, but that's all right. It's not required. We're not in federal court, so okay, that's good. So go ahead, Attorney.
Much appreciated.
Okay. All right.
So if folks don't have it in front of them, I'll talk it through very, very slowly and clearly and explain the relevance of dates as we go. So uncontested, the permits were first issued November 15th, 2011. So that's the start date of the permit period. Everything starts running then. The next really key relevant date was actually left off of this timeline, and that's February 27th, 2012. And that is the date that this body initially revoked their building permit as part of that initial appeal. So that's the first date that they weren't allowed to construct or commence construction. And that's a really significant date because there's a pretty significant period in there. November 15th to February 27th is 104 days. That's a good chunk of their 180-day period. And so the permit was running during that period, 104 days. They could have commenced construction, did not. This board then revoked the permit, and that put the permit on pause. That leaves 76 days of that original 180-day period remaining. So then if we start at February 27th, the date the permit was revoked, and we assume that the permit period was on pause the entire way through the last possible appeal, October 30th, 2015, and if we assume that this Permit Extension Act runs sequentially rather than consecutively, this is all assuming application of the law favorable to Palmer. Even if we assume that, the pause would have lasted until October 30th, 2019. So that's the appeal of the original revocation was done October 30th, 2015. Assuming the 4-year Permit Extension Act runs until October 30th, 2019. And so if we restart the clock October 30th, 2019, and they have 76 days left of that original 180-day period to commence construction, that gets them to about January 14th, 2020. And that's it. That's the end of the longest possible reasonable timeline that they could have commenced construction in. And if they hadn't commenced construction by January 14th, 2020, the permits lapsed. So that's it. Palmer will argue that the 180, and Palmer has argued in their response to this appeal that the 180-day period starts on October 30th, 2019, that none of those 104 days before the permit was revoked count.
Okay. Can you just for purpose, do you mind just slowly just repeat that again, please?
Yes. So Palmer, in their response to this petition, asserts that the 180-day window to commence construction doesn't start until October 30th, 2019. Okay. And that's really significant that those 104 days in the initial permit period are being ignored, and it's a consequential lapse of inclusion of that time. Mm-hmm. They'll argue that the filing of the appeal may have started the tolling, but none of the cases cited support that proposition. Everything that they point to say that the permit should be on pause during that period is in reference. These are all cases where an appeal had some legal or practical impediment to their use of the permit. So where there was an injunction, for example, or where they got a variance granted, but then due to the appeal of the variance, a special permit to use that variance was never granted. So these are all cases where there's actually some impediment to the use. There was no impediment to Palmer's use in that period until February 27th, when this board revoked that permit. That's when the period starts.
Okay.
And the case law supports this well. You know, there are several cases that refer to the time of tolling, and for example, Cape Ann v. City of Gloucester, 1976, cited in the Code Enforcement Commissioner in his January 2019 letter to the City Council. This is Exhibit 1 of Palmer's response. There's some good language in that case. Footnote 5, I'll quote and read here. The matter of the running of the statutory period is now significant, and the amended judgment should be revised to reflect the suspension of the running of the 3-year period from the date of the denial of the building permit until the disposition of all bona fide appeals from the denial or granting of city permit from the City Council. So that from the date of the denial is the relevant piece there. What they're really talking about is when you could no longer use the permit because of an appeal or because of some legal impediment, that period should be put on pause. There was no such impediment in our case until February 27th, and so that period should run those 104 days.
When was the filing to your not? So they might argue. What you're saying, you're anticipating that they might argue that or are arguing that when they filed the appeal, when was that filing? When it's not on this timeline, I don't think.
Yeah. So to clarify, they have argued that the permit is told, at least in this filing, from the date of issuance, and I don't see any support for the idea that the permit was told before the appeal was filed. I would be interested in what that argument would be, and so anticipating an alternative argument that the permit would be told based on the filing of that appeal. That date was, I believe, December 11th of 2011.
Oh, okay. So on the December 11th, on the first page of their timeline, where it's December 11th, 2011, in the far right column, significant states appeal tolls the running of the deadlines under the building permit. When they say appeal tolls, they mean the filing of the appeal there.
That's right.
I mean, is there any case law about, as long as it's not a frivolous appeal or something, that as long as they have a prima facie case that tolls, that a filing indeed does toll, does stop the clock?
So there are cases that deal with a circumstance where a permit was revoked and then reinstated, and the appeal of that reinstatement will toll a permit period, but there's no case law on the initial filing of an appeal having that effect. On your question as to non-collusive, bona fide filing, there is case law related to collusive filing, and that is where there is an impediment to the use of a permit. Collusion can be used to essentially get rid of the tolling effect of an impediment.
Okay.
But a showing of a non-collusive filing is not by itself enough. There has to be some showing of impediment or a subsequent appeal. Mm-hmm. There was no impediment until February 27th here.
Okay. All right, go ahead.
Great. So having established that timeline, I'll turn now to the failure to commence construction. I want to start right here out of the gate to note that on this question, the State Department of Environmental Protection earlier this month revoked Palmer Renewable Energy's air permit for failure to start construction. It's a slightly different set of facts at play because the permit was issued a little bit later. It didn't qualify for the Permit Extension Act, and they had a 2-year period to start construction rather than 6 months. But nonetheless, the conclusion and the observations that they based that conclusion on are very relevant here. So I'm going to read a few lines from DEP's April 2nd letter revoking Palmer Renewable Energy's air pollution permit and describing how they reached that conclusion. So, quote, on February 2nd, 2021, Mass DEP inspected the site to verify the construction status as represented by PRE. Mass DEP reviewed the submitted information and site observations. Mass DEP has determined that PRE purchased property near and adjacent to the facility, created an earthen berm, demolished an existing building, and allegedly negotiated with Eversource to include a switchyard near the facility instead of at a different location. In addition, there is currently a large pile of recycled asphalt on the site within the proposed footprint of the PRE biomass-fired facility, which precludes construction of the actual PRE biomass-fired power plant until that pile is moved and the underlying property is prepared for construction. Mass DEP has determined that PRE has performed certain site modifications for the facility, but has not commenced construction within 2 years of the date of the plan approval. So they did a site inspection, I believe it was February 2nd, so just earlier this year, and there was a large, literally a pile of asphalt where they want to build this thing. And that was by itself conclusive that they had not commenced construction because That's the first thing you would do. You have to get what is there at the site where you're going to build it out of the way before you can do any of the grading or site prep to build the thing. And so that was by itself enough for Mass DEP to determine, at least as of their February 2nd inspection of the site, that that construction had not commenced at the site. And reviewing the information provided, I think you'll come to the same conclusion that Mass DEP did. They've done some modifications to the site, but nothing that rises to the level of actual construction. And so I want to help define, commencing construction is a term of art for the purposes of the law, and it's something that has been well defined by the case law. And so I want to start with a couple of quotes and apply them here. Reading from the 2010 Massachusetts Land Court decision in Silverleaf Resorts, included in the filing. Quote, generally, anything short of actual construction work has been considered mere preparation rather than substantial use or construction, end quote. And so what we're talking about here is site prep or preparing for construction is not the same thing as construction. So they're really talking about breaking ground, laying this foundation. That is construction. Acquiring neighboring sites and so forth, entering into contracts, spending money to advance the project does not constitute commencing construction by itself. So Palmer Renewable Energy points to a continuous construction report listing all of the activity that they have undertaken at the site, including these contracts, acquiring and modifying neighboring parcels, but nothing that they list there rises to the level of actually commencing construction at the site.
Attorney Epka, can I ask you a question?
Of course.
What's the spirit, sort of the policy behind that? If you could elaborate a little bit behind that decision, why they're splitting, anything short of construction? What do you think where was the court coming from in that, with that decision?
Well, I think the purpose of the 180-day limitation is so that developers don't take out permits and then string them along for years to avoid new rules being imposed on them. They don't want to get, they want to get grandfathered in, and this is really to ensure that subsequent ordinances are complied with, and that they are that they're diligently pursuing what they have sought a permit to do. So, mowing the lawn or site prep, stuff like that doesn't count. There, the 180-day window is meant to be that generous window in which they can get the business affairs in order and start construction. There's no requirement that they begin construction on day one.
And I don't see any that you've alleged that, and I wouldn't assume that you are. I mean, in your argument, I mean, unless I missed it, that indeed was the case here, where there was trying to postpone this for some some benefit to avoid some regulation or something like that, or you just use that case law because it's it's just supportive of your argument?
Well, there is indeed a subsequent ordinance. I can't speak to the intent of the permittee, but they are indeed avoiding a subsequent ordinance that would require them to get a special permit. If they sought this permit now, they would have to go through a special permit process in order to obtain and build the facility. And so whether or not that was the intent of the permittee or of Palmer Renewable Energy, I'm not sure, but the force of the law or the intent of the law is meant to ensure that those subsequent ordinances are abided by. And we're talking 8 years now later than the ordinance was passed that would have required them to obtain a special permit. And so that is the requirement of the law. That's the effect or the purpose of the law. And I think that the Springfield zoning ordinance requires that balance. Certainly the consistency for the developer, their ability to have a fair process, and also the community concerns and nature of the community. These things change over time, and the Springfield City Council has an interest in ensuring that their ordinances are abided by.
Go ahead. I know I interrupted with that question. So
sure. No, thank you for raising that. I'm happy to speak about that further in later conversation. So I also just want to identify that that quote is not an outlier. We're talking about, this is pretty consistent throughout the case law. I want to point to the only actual activity on this site beyond signing contracts and so forth is the demolition of this structure. And I want to raise two deficiencies with that argument. First, the demolition of the existing structure isn't enough by itself to constitute commencement of construction. One of the seminal cases in this area, Alexander v. Building Inspector of Provincetown, 1966, commencement of construction requires, quote, more than preparation for new construction, end quote, and specifically references removal of standing buildings and leveling off of subsequent debris. The second flaw with the raising of the demolition of the structure is this structure isn't even on the instant parcel. We're talking about a completely different parcel unrelated to the permits at hand. It's a neighboring parcel where they removed a building in order to move things from the site to this adjacent parcel in order to construct the power plant. There is no requirement in this permit that they perform any of this activity. This all could have been done well before seeking of the permit. I think there's, in response to your question, I think that there's an element of business consistency, but also business risk here. If they knew that they had years of work to do before they could start building here, they shouldn't have sought a permit to begin construction within 6 months, right? This is the kind of thing where a permit seeker would need to make sure that they have their ducks in a row before applying for a permit if they want to commence construction within the permit period. Just allowing them to begin construction essentially whenever they feel like they're ready to start construction is not what the law requires, and I think runs afoul of that policy as discussed.
But they also couldn't have, at the time, I mean, they back in 2011, 2012, they couldn't have anticipated our revocation of our denial back in 2012. I mean, how does that play in? I mean, here, let me go. I'm sorry. Let me go back.
Yeah, no problem. I mean,
I might be thinking out loud a little bit here. So in the ZBA revoked the permit back in 2012, right?
And they didn't even acquire this neighboring parcel until 2014.
Oh, okay.
Right. They knew they needed to move this asphalt somewhere before they could begin construction.
I understand. Yeah. Okay.
If they didn't have a plan for that when they applied for these permits in 2011, that's on them.
Okay.
Right. So that they acquired this parcel several years later, I will note during the tolled period where they claimed that they shouldn't have had to diligently pursue this project, they acquired the neighboring parcel and began work on that. They didn't demolish the structure until, again, several years later. And so there were fits and starts. And again, none of this is the permitted activity. We're talking about building a foundation for the stack and doing the site grading. None of that work has started yet. So all of this preparation, as far as the law is concerned, does not constitute commencement of construction. It's all related activity and all things that they could have done before seeking and being granted a permit.
Yeah.
Okay.
So just to reiterate, they had a valid permit to commence construction from November 15th, 2011 to February 27th, 2012, and then again starting October 30th, 2015, all the way until January 14th, 2020, and they did not commence construction within that period that they needed to. So this is a completely remarkable situation. We have a 180-day permit now that is still in effect nearly 10 years later, and if not revoked now, I don't know when it will expire, if ever. I'd be interested in hearing whether the petitioner or the zoning enforcement officer has an opinion as to whether or when this permit would expire, if not now. We're well over when they should have commenced construction, and it could continue into perpetuity if not now. So I guess I'll just close by saying that I look forward to questions. I'm happy to join next week and continue the conversation. And I'm additionally happy to draft an order of decision for review of this board to adopt for your use if that's of interest of help.
And I have a, what's that? Does someone?
Go ahead.
A question. So I know that you've focused the accrual of the 180 days between, you know, the original November 15th to the 104 days to February 27th, 2012, and then again, you know, in 2020, the remaining 76 days.
Correct.
Are there any? I mean, I would imagine that. Well, I've read the filings, anyways. But I mean, aside from the original 104-day accrual, are there any other periods of time besides where you've cited the 76 days up in all the way in 2020? Are there any other periods of time where you specifically see a running of those days?
Well, there are several interpretations that could lead to further running in that interim period. So, for example, the Permit Extension Act adds 4 years to the legal term of a permit granted. And I don't know of any support for the notion that the 4-year period should not run consecutively to this tolling offered by litigation. So this Permit Extension Act, as you all may well know, was passed by the legislature in 2010 and then again in 2012, extending permits due to the 2008-2009 financial downturn and the effect that had on development. And so they meant to give folks that had a permit an extension, some extra time to get their finances in order and so forth. And so we are generously assuming in this circumstance, if the Permit Extension Act begins October 30th, 2015, this is, we're talking 3 years after the passage of this Permit Extension Act. If they get to tack on their 4 years after the litigation tolling, then that only gets them to October 30th, 2019. But I think it's a perfectly reasonable interpretation that the Permit Extension Act was meant to run those 180 days plus 4 years, period. Not that the Permit Extension Act would itself also be put on hold with this litigation tolling. I didn't feel it necessary to get into the argument about that because it seems a pretty new area of law in terms of interpretation out there available for that. And I didn't want to rely on it because I don't think we need to. I think that this period between the issuance of the permit and the initial revocation is much more clearly part of the running of the permit period.
Okay, thank you. Are there any other questions for Attorney Epka?
Yes, Mr. Chair, I have a question.
Mr. Roldan?
So the total permit, if I understood right, you said there's 10 years of this running constantly. It's about 10 years, you said? So even if we added...
Sorry, I was just going to say the permits were originally issued November 2011. So we are approaching 10 years after the issuance of the permits.
Okay. So even with the act, and giving them the 2 years and giving them the 4 years, even with the act, that's 6 years. So they're way past their term of time limit, I would say, unless there's a dispute on the start date.
So it's actually a 6-month period plus 4 years. So they get 4.5 years. They're also adding a pause due to the original appeal. So because their permit was revoked February 27th, 2012, that put the running of that period on pause. And so if you add up the lawsuit and the 4 years and the 180 days, that only gets them to January 14th, 2020.
Correct. All right. Okay. Thank you.
Thank you.
Mr. Chairman, Walter Gould, I have a question.
Yeah, Mr. Gould, sure.
Attorney, didn't PRE appeal the decision from the DEP that just came down, I believe, in February that you had just mentioned earlier?
They did indeed, and it's possible that they can win on that appeal and that you can at the same time conclude that they had not commenced construction. I think that the observations of DEP about the fact that there is a pile of asphalt in the footprint of where they would build this on February 2nd, 2021 is pretty conclusive that they had not started construction by January 14th, 2020. Whether or not the the 2-year period for the DEP permit is challenged successfully by Palmer Renewable Energy, I don't know that that's relevant. As I said, the facts are a little bit different. They have it's a different permit issuance date. It's a different permit period. But the fact that there is a big pile of asphalt where they want to build this thing a year after they needed to start construction is pretty compelling to me that they had not yet started construction then.
Okay, so obviously the state hasn't rendered their decision on the appeal then.
That's correct. It is pending. I believe it's an internal appeal within DEP, and there are subsequent appeals available to Palmer Renewable Energy. I imagine that process may take some time before we have a final decision there.
Thank you, Councilor.
Mr. Chair,
Yes, Mr. Roldan.
I have one more question. It's directed to Paul Yocum. Have you ever seen this in the past where we have a permit issue that would run that long for
Mike
construction?
Yocum? Okay.
Mike Yocum, yeah.
Well, not this long that I'm aware of.
Thanks.
Nothing comparable is what I think he's asking that we can.
No.
Okay.
What
I would welcome the petitioner to submit any evidence that there has ever been a permit in the Commonwealth to commence construction within 180 days that is still in effect 10 years later. I'm not sure I've ever seen one.
So Attorney Epka, I know a lot of this is splitting hairs, so I'm gonna ask you to split hairs again. In terms of the cases you cited and, what was distinguished, sort of recognized as short of construction, was there anything regarding something that is so essential to construction, but is pre-construction that it would tip it in the favor of being part of part of the construction project versus prep, even though generally we know that it's pre-construction, but something that is so essential? And if so, anything that if so, how would you argue against that in this case?
Yeah, I mean, I think that seminal Alexander case addresses that very clearly, that demolition of existing structures and clearing the site to prepare for construction does not constitute construction. That's clearly parallel with what we have here. The moving of the asphalt pile would be considered preparation for construction rather than actual construction.
And in this, the case you're referring to as a seminal case, is that demolition, was it cost? Was that demolition usually is, but in that case, was that a large expense for the appellant?
I can't speak to the burden or financial hardship that the demolition caused.
In comparison to the pile of asphalt,
look into
I suppose. In comparison to the pile of asphalt, I know that you're saying that it's not a matter of finance; it's more of a matter of it's pre-construction or not pre-construction, or construction. But I just am still interested in, sort of globally, if a petitioner spends a significant amount of money over the 10 years, and there are items that are essential to construction, even though they're termed pre-construction, if sort of both of those elements somehow globally add up to, enough to get them past past their burden. But maybe that's something I really need to ask I know not the petitioner in this case, but the respondent in this case.
Well, I will offer, Mr. Chair, the question of finances has been addressed and dismissed as not
Right.
relevant to the
Right.
construction of or the determination of commencement of construction.
Right.
Another issue that I will offer the board is that the permit not only requires commencement of construction within 180 days, but it requires continuous construction. And so
Yes.
if there was at some point during this period some little piece of activity that may have technically started construction, which I don't concede at all, I don't think they have done anything that rises to that level. But even if they had, the idea that they have continuously pursued this and that there were no pauses in construction that would invalidate the permit would be surprising to me.
I don't think we'd be here today if there were ever construction. It wouldn't be at this dispute. You know what I mean?
Right. Right. So if you have, I'm just actually charging my phone. I stopped the video so I can charge my phone while I'm doing this. I should have done this before. So Attorney Epka, do you have anything else to add, or are there any board members with any more questions?
Say that again?
Attorney, are there any other board members with questions for Attorney Epka, for the city council attorney?
No.
Okay. Okay, so let's move on. I thank you very much, Attorney Epka. Is there anybody else that would like to speak in favor of the petition? Anybody else that would like to speak in favor of the petition? Okay. Is there anybody that would like to speak against the petition?
Mr. Chairman, my name is Peter Durning. I'm an attorney for Palmer Renewable Energy, LLC.
Thank you. Yes, Attorney Durning. Would you mind just stating your full name and address for the record?
Certainly. My name is Peter Durning. I'm an attorney at Mackey Shea Durning, PC, which is a law firm based in Boston at 20 Park Plaza, Boston, Massachusetts, 02116.
Thank you, Attorney Durning. I appreciate it. So we'll hear from you now.
So, Mr. Morrissey, do I have the ability to share screen? Is that possible?
Sure. Is this something that, yeah, go ahead. Yep.
So I have a short bunch of slides to walk through that I think will help illustrate some of the issues before the board today. And I'd start by saying I think that this matter has a rather complex history.
Attorney Durning?
Yes.
Can I just confirm, and I'm sure this is probably a silly question, okay, but I just want to make sure that everybody, it's probably a silly question for me. I'm not that new to Zoom, but is there anyone that cannot see the screen now that's titled City of Springfield Zoning Board of Appeals and dated April 28th, 2021? Okay, so everybody can see that, correct?
Correct.
All right.
Correct, yeah.
Okay. All right,
Great.
Go ahead, Attorney Durning.
Thank you for that confirmation, Mr. Chairman. I appreciate that. So as I was starting to say, I think that this matter has a rather complex history, but it presents a relatively straightforward analysis that should be resolved with the ZBA upholding the February 23rd, 2021 decision of the building inspector. As we presented in our written response to the petition, and as I will amplify in my comments this evening, the building permits issued by the building inspector to PRE in November 2011 are still valid and have never lapsed. Since they are still valid and PRE is within its rights to continue to act in reliance on the building permits, the petition should be dismissed and the building inspector's denial of the request for enforcement should be upheld. Put simply, as presented in our response, by operation of the Permit Extension Act and the COVID Emergency Act, the deadline to commence construction has not yet arrived. Therefore, the building permits are still valid. In reference to the DEP process that was brought up, I would note that the DEP revocation is not effective, that PRE has filed an appeal, and the hearing officer at the Office of Appeals and Dispute Resolution within Mass DEP has confirmed that the revocation is not effective unless and until that adjudicatory process concludes that the revocation was appropriate. So that is still undecided. And as Attorney Epka noted, the timeline and the review that DEP is going under is different, and that information.
Conversation. No, George. I don't care what you say.
One moment, Attorney Durning.
All right. You got 40.
Attorney Durning, one moment, please. If board members and anyone else that's on the call could kindly just mute their, I mean, I will stay unmuted. And of course, if someone, a board member has a question, that's fine, unmute yourself. But until then, if you could just remain muted, that would be great, especially for the continuity of the, Mr. Attorney Durning's presentation.
I appreciate that, Mr. Chairman. That's fine.
Sure.
So this is a digested version of that timeline that was on in the appendix for this matter. And I note Attorney Epka is correct. It does not necessarily show the date of the revocation by the ZBA. I think it's a rather a bit of an officious differentiation to make with the City Council appealing the building permits on December 11th, 2011. I'm not sure that any party would have expended the kind of investment that would have been required while that building permit appeal was pending between December 11th, 2011 and February, I think you said 23rd, 2012. So to the extent that difference is material, I think the better date to use is December 11th, 2011. I don't think that Palmer Renewable Energy would have been obligated to proceed at the risk with its building permits under appeal at that time. I'm not going to walk through all of the years of litigation that you have in the appendix. I think that Attorney Epka, for the purposes of this matter, concedes that the operative date at the conclusion of the various appeals that were pending with respect to the building permit specifically, that does not conclude until October 30th, 2015. And that's the date on which the Supreme Judicial Court in Massachusetts denied the City Council's request for further appellate review. So that is the date upon which the tolling due to the extensive litigations were running. And I guess I just assert that the position that the Permit Extension Act grant of a 4-year tolling period should have been running concurrent with this extensive appeal history. I don't think that that is logical, nor was that the intended benefit of the Permit Extension Act. No party would be able to act in 2012, 2013, 2014, up until October 30th of 2015 with those appellate activities taking place.
You're saying no company would reasonably put all that capital at risk and start and break ground while really there's unsteady legal ground, happening in the background, correct?
That's exactly correct. And I think the tolling due to litigation is appropriate in this context. I don't deny that it is a long period of time, but unless and until Palmer reached the end of the appellate period, it was able to toll those against the effective period of the permits. Otherwise, if they were running concurrently, project opponents could just proceed with appeals and allow the clock to run out. That's not the way zoning approvals work. So if we get to the operative date of October 30th, the date on which the SJC denies the request for further appellate review, going forward, the building permit holder, Palmer Renewable Energy, gets the benefit of the Permit Extension Act simply by operation of law. So Was
Do
there
you
a question?
concede, Attorney, do you concede though that, so if you use between November 15th, 2011 and December 11th, 2011, would you concede that there's about 26 days there?
I in my outline here, I don't think that I incorporated it, but I think that that is appropriate for the ZBA to consider that.
And how do you feel about Attorney Epka's position that the filing of the appeal does not stop the clock?
I think if we could transport ourselves back to December, January 2011 and 2012, I think it is too much to ask that Palmer Renewable Energy should have been expending the amount of dollars that would have been required to commence construction on an energy facility while their permits were under review and potentially being revoked, which in fact happened. So I think the December 11th date is the appropriate date. And yes, sometime in the 180 or the 1 year clock did start to run, but I don't think that goes all the way to February 2012.
Would it have been normal? I mean, I guess if they're, I don't know who really could have possibly had the foresight at that point, but at the filing of the appeal on December 11th, 2011, I'm sorry, when it actually finally came to be heard the first time, if there could have been, an additional, like some type of motion to retroactively to have the court, toll the running of the deadline. I mean, I guess you wouldn't have known to do that, 10 years late. Go ahead.
No, I think it's not a bad suggestion, Mr. Chairman. But on the record of this, I mean, I think no one knew exactly when it would stop and what the resolution would be. There was concurrent litigation and an adjudicatory proceeding and subsequent litigation happening on the air permit. There were a lot of things that were potentially in jeopardy, and Palmer Renewable Energy was expending its energy defending and securing the rights that it had initially obtained. But I hear what you're saying, but there was no judicial pronouncement upon the resolution of any of those appeals that said henceforth the permit period starts anew or that X amount of tolling has taken place. I mean, I think the proper avenue and body for reviewing that is the building inspector himself, subject to your review. And as we'll talk in a moment, when the building inspector, Mr. Desolate, reviewed this matter, he found that the timeline was appropriate. So just in short, that the Permit Extension Act is it is unusual in the realm of zoning, but it is very straightforward. The Permit Extension Act allowed for the extension of any permit or approval that was in effect or existence during the relevant tolling period under the statute to be extended for 4 years, in addition to the lawful term of the approval. So from October 30th, 2015, extending that 4 years would take you to October 30th, 2019. Using the 180 days for the Massachusetts Building Code for the commencement of construction, 180 days from October 30th would be April 27th, 2020. And under the review as to whether or not a zoning change under General Laws, Chapter 48, Section 6 would occur, Palmer Renewable Energy would have 12 months to commence construction from October 30th, 2019, or that would take it to October 30th, 2012. If we built in some allowance for the 26 days that had expired before the filing of the appeal of the building permits by the city council, I think that date would still take you somewhere around April, for the 180-day clock would take you around April 1st of 2020.
April what of 2020? Say that again, please.
I think I'm doing the math on the top of my head, but
No, that's
I think
okay.
if it's 26 days from the approval to the appeal, I think it would roughly take it to April 1, 2020.
April 1, 2020. Okay.
So as I flagged before, and I think it's important to note that this matter came before the building inspector in January 2019, where
Yeah.
the same party, the city council, filed a very similar repeal petition asking the building inspector to revoke the building and permits for the expiration of time. And now the building inspector's decision on the application of the Permit Extension Act is the law of the case with respect to this project. A note that the building inspector's determination on January 17th of 2019 was never appealed. And these parties, the city council in particular, needs to be held that they too have now agreed that this is the law of the case and that the Permit Extension Acts do apply to this matter. One slight correction I would make in the observation from the building inspector in this January 17th, 2019 decision is that he starts the running of the permit extension clock from September 8th, 2015, which was the conclusion of the appeals court matter. But since the city council filed an application for further appellate review to the SJC, the
Right.
proper date would be understood to be October 30th, 2015,
Okay.
the date that that application was rejected. But again, this is the law of the case, that the Permit Extension Act gave Palmer Renewable Energy 4 years from the conclusion of the litigation tolling period. And I think that that's binding on the ZBA, and it should be binding on the city council that they did not appeal that decision of building inspector Desolate.
And that 4 years begins what, say, I'm looking at your timeline. I know you have this on the screen here, but I'm looking at the timeline you filed. So that 4 years begins, what date are you? attaching it to?
October 30th,
Yep.
2015,
2015.
the date of the
2015.
SJC's denial of the application for
Okay.
further appellate review.
Okay.
So
Which brings
use
us to October. Sorry, go ahead.
That's fine, Mr. Morrissey, which would bring us to October 30th, 2019.
2019. Okay. Yeah.
And what we would then have is either 180 days under the Massachusetts Building Code, or again, for the protection for any changes in zoning, a year from that date. Again, the Permit Extension Act adds on a tolling period of 4 years plus the lawful term of the approval.
Mhm.
But what we have in the midst of the running of that period from October 30th, 2019, is that on March 10th, 2020, pursuant to Chapter 53 of the Acts of 2020, the COVID Emergency Act, all permits that were in effect as of March 10th, 2020, March 10th, 2020, were automatically preserved during the state of emergency, the state of emergency that we are still in. So while I would acknowledge that the circumstance of the duration of a building permit is a bit unusual, it is merely the application of the tolling periods that have been provided by two rather extraordinary statutes, the Permit Extension Act and the COVID Emergency Act. So go ahead, Mr. Morrissey.
Does any time run, or do you concede that any time runs then between October 30th, 2019 and March 10th, 2020 or not?
Yes, the clock is the effective period of the permit is running as of October 30th, 2019. That
stops
correct.
March 10th, 2020.
And then it is stopped again by operation of the COVID Emergency Act. Correct.
Okay.
So I'll flag in the papers, there is a note that that you could do another timeline based on the effective approvals of the air permit. But I think for the purposes of your review and for the purposes of the review of the building inspector's February 23rd decision, the right analysis is on the building permits itself. So I think that's the proper way to go. I guess just in conclusion, I would say that by operation of law, in particular by operation of the Permit Extension Act and the COVID Emergency Act, PRE's time to commence construction under the building permits has not expired, and any revocation based on the expiration of time to commence construction would be an error of law. So that's my presentation, Mr. Chairman.
All right, can you just one moment? Let me just read this highlighted portion here that you have on the screen. Okay. Another question, and I want other board members to chime in, please. But another question is an issue brought up by, well, is it subsequent to a question from me, but by Attorney Epka, was that sort of the spirit, the policy behind some of this case law is, to avoid regulations that might come up, more stricter regulations, so on and so forth. I mean, can you speak to as whether the new zoning ordinance from what was enacted, 2017 or 2015 in Springfield, the new zoning ordinance?
2014.
2014, sorry. Did that, I mean, can you speak to that issue, Attorney Durning? I mean, was that on?
Sure, I can speak to that issue, Mr. Chairman. And I think that the plain view of it would just be that Palmer Renewable Energy was entitled to rely on the operation of the statutes. Palmer Renewable Energy was entitled to rely on the operation of the Permit Extension Act, which gave it an additional 4 years. And again, I would note that the building inspector came to that same conclusion in 2019, and this petitioner, the city council, did not appeal that decision at the time. So again, I would assert that has a rather preclusive effect, that the Permit Extension Act does apply in the very way that I've articulated it. Again, I think that the issue is one of reasonable reliance by Palmer Renewable Energy. They had the ability to rely on the operation of that broad state statute, and I think that's the appropriate avenue for assessing the operation of that law.
So stepping us, or maybe you don't want, for purpose of your argument, I'm not sure if you want to step aside from the timeline itself, strictly relying on the timeline. How do you, the issues of continuous construction and pre-construction versus actual construction, breaking ground, so to say, how do you, in whatever order you see fit, how do you respond to those two issues raised by Attorney Epka?
Certainly. I mean, I think our frontline argument is that we would argue that the permits are still valid. To the extent there's an issue of commencement of construction, I think we've dealt with it in our papers, and I refer to the 2-page summary provided from the representatives of Palmer Renewable Energy. And I think that these expenditures and these activities are significant and should be taken into account by the ZBA's review. Is it going to be the case that a backhoe has not shoveled the foundation for this energy facility? That may very well be the case, but I think in this complex system that was going to be built, that a lot of the work that was performed was necessary and appropriate and could be construed as the commencement of construction.
Mm-hmm. And as to continuous construction again?
Again, I think I'd refer to the timeline that we included, and that building inspector Desolate included along with his opinion, that he was appraised of those activities and he came to that conclusion as well.
Mr. Chairman, I have a question.
Mr. Roldan?
So I'm hearing that you were saying that somewhat was started for construction. You had made some movement for construction. And I could be wrong, I'm not an expert at any construction, but I know that working at Bay State, when we pull our permits, it's day ones when we break trouble. What's the difference from us or any corporation that would pull a permit and start construction from what this specific construction would be?
Sure.
What's the difference?
Thank you, Mr. Roldan. And I'm not sure if you mean in terms of what Palmer Renewable Energy could or should have done in November 2011 or in January 2012, or what it could or should have done more recently. But there were challenges to these permits, and I mean, I hope for Bay State's benefit that their permits don't get appealed to the length that Palmer Renewable Energy's permits got appealed to. But given the length of the litigations, those told the operation of those permits. And then again, by operation of the Permit Extension Act, Palmer Renewable Energy was within its rights to rely on that extension. As I'll refer to the exhibit that Palmer provided, that there were extensive activities taking place as well, but that does not rule out the benefit that Palmer had the ability to rely on the operation of law there.
Okay, I understand that part, but out of goodwill, construction itself was
Right.
I don't see the effort, right? I don't, I as I explained, the site is not even touched or prepared, and I understand that, I understand the COVID areas, the issues, because we dealt with that as well. But there's always something started, right? Because it's totally different when it comes to COVID, when it comes to construction, somewhat. It never stopped, right? It just, the rules change. So knowing that the rules change a little, but construction continue on, what would it make it different? My question, what would, besides the rules and regulations that they're adding to you guys and the appeals, the construction piece, what would have been different?
I'm not sure that I can speak to that directly, Mr. Roldan, but I think in terms of by operation of the COVID Emergency Act, I don't deny that certain construction activities could have continued during that period. But I also think it needs to be recognized that by operation of that law, it told the running of any effectiveness of a permit. So I think both things can be true, and I think that the ledger in the continuous construction report shows that there was a considerable amount of activity. I think the bottom line that they say is that over $4 million have been spent towards advancing this work, and that's a considerable investment of effort and dollars.
So I sort of I think it maybe piggybacking on Mr. Roldan's question is, I mean, on the one hand, you're saying that, nobody can be expected to break ground and, with the risk and spend all of that money when things are in litigation. On the other hand, you're also saying, though, that what you did do does amount to a significant investment, and it does amount to construction. So how I sort of resolve how you can have it, not you, but how PR3 can have it both ways on that point.
So I think there are two moments of inquiry there, Mr. Chairman. So the report of continuous construction, I think, starts with activities occurring in 2018 and then runs forward. That's different from any obligation to incur costs in the period from 2011 through October 2015. So I think the lens of inquiry, the time of inquiry is what's different there. But I understand your point, but I think, again, there are significant differences in the inquiry of what monies should be expended during the pending appeals and what monies could be expended as they're still enjoying the extension of the Permit Extension Act.
Okay. Any other questions from board members?
No, just trying to digest all this, that's all.
Right, no, definitely, there's plenty of food for thought.
Yes.
Okay, I mean, there's also, I mean, we think of questions, I guess, during the week, there's a possibility for follow-up, but anyone else right now have anything on their mind? Any questions for Attorney Durning? Okay. All right, Attorney Durning, I think you already concluded. You were just sort of responding to some questions, correct? Do you have anything else you'd like to add?
No, I thank you for the opportunity. I will be back next week if there are additional things you'd like to pose.
Okay, that's great. So is there anybody else that would like to speak in opposition to the City Council's petition? Just make sure you unmute yourself. Is there anybody else that would like to speak in opposition to the City Council's petition? Okay. Attorney Epka, are you still available?
I am indeed. Thank you, Mr. Chair.
Okay, so because there was opposition, we allow you 10 minutes for rebuttal.
Okay, great. And I will need it because there are several pieces that I feel I need to correct in that presentation. First, my understanding is that the motion for a stay requested by Palmer in the DEP case was denied. I'm not sure that that has the effect of putting the order into effect now, but that's a piece that I understand has moved. I also feel it necessary to just reflect on what I have and haven't conceded. I heard Attorney Durning state that I had effectively conceded that October 30th, 2015 or 2019 was the date that the tolling stopped. And I think I was pretty explicit that I did not concede that. I think that this question of the Permit Extension Act period running is very much unsettled. The idea that we are bound or precluded from addressing that issue based on a letter from the code enforcement officer. I don't read that letter as conclusively saying that the Permit Extension Act period runs subsequent to litigation. I don't see that anywhere. And to your question, Mr. Chair, about the effect of them running concurrently rather than sequentially, that idea that an opponent could just appeal and appeal to run out the time would not invalidate a permit. The permit is told during the litigation for that purpose, so that the permit period is paused while the permit is being disputed. The Permit Extension Act, on the other hand, gave them 4 years after the financial downturn so that the economy could correct. There's no reason that those two tolling periods shouldn't happen at the same time. The idea that after a challenge to the litigation, yes, the 4-year Permit Extension Act may expire during that period, but that's fine because it's doing what it was meant to do, which is give them more time. They're getting that time. The litigation tolling at the same time does what it's supposed to do. It puts the permit on pause while there's litigation. So the idea that an opponent could appeal to run out the timeline on that just doesn't quite work. They get the time anyways, meant by the Permit Extension Act, and they get put on pause during litigation. So I do not at all concede and do not feel that we are bound or precluded from addressing that issue. I just didn't get into it earlier because I felt it wasn't necessary. I also want to point out that the code enforcement officer, the zoning enforcement officer, repeatedly made reference to construction starting, not reference to the period continuing. I feel like the party line changed after the DEP decision that construction had not commenced from we started construction to the period to start construction has not run. So that tune has changed a little bit, and I think in response to that, but I don't want to speculate too much there. My main point, though, is if this body agrees that the permit was told upon filing of that appeal, December 11th, 2012, right, that would be creating new law. That is not supported by the cases There is no impediment to their use of the permit at that time, and therefore there should be no tolling. Similarly, consideration of the millions of dollars they may or may not have spent in pursuit of this project, consideration of that as a component of the commencement of construction analysis would similarly create new law. These are, whether or not you agree with the policy there, whether or not it's a good idea, the support there does not exist in the case cited. So I just want to be very clear that this is.
How do you address then the point by Attorney Durning that, you know, why would a company in their right mind risk breaking ground, you know, back in the beginning of this case, you know, while there's litigation, you know, when they filed the appeal, why would they run that risk?
Well, it seems that they did. I'll point to the fact that they acquired this neighboring property in 2014 before the appeal had run. So they were making substantial expenditures.
So they could have made the same expenditures, but made it on construction is what you're saying, but they made it on sort of, you know, secondary issues that don't.
Right, even after the permit had been revoked, they continued to pursue this by spending money.
Right.
They were actively involved in trying to get this thing to work. They just never got the pieces to put it together at the same time. You know, the permits weren't there at the right time. And the idea that the mere filing of an appeal is so speculative. There's no guarantee that they would have their permit revoked. You know, there are so many appeals that don't have substance, not that this one didn't. They obviously won at this body and got that permit revoked. But the seriousness of a previous revocation through the appeal process is very different than the initial filing of an appeal. And I think that bears out in this case, the idea that they continued to pursue by, you know, purchasing this property to do the interconnection agreement with Eversource, but they never got it together to break ground.
Mm-hmm. Okay. Anything you'd like to add, Attorney Epka, or any questions for Attorney Epka?
Happy to answer any questions.
Okay. So are you finished, Attorney Epka? Not to, I mean, you have more time on your 10 minutes.
I will cede it. I'll yield.
Okay. All right. No more questions from board members then?
No.
Okay, so we have gone through the petitioner, we've gone through anyone else in favor and any opposition. So we've heard all testimony for this evening. Excuse me. With that said, we'll conclude this portion of tonight's hearing. Just so both attorneys and city councilors, and I also, just as a matter of courtesy, I did want to recognize public servants that are present for this meeting. As I scroll through here, I know that City Councilor Jesse Lederman is present. City Councilor Michael Fenton. I know that we had City Councilor Tim Allen was also here.
I'm Dan, I'm still here. I got the wrong name on the box. So
that's fine. It's not your proxy. I got you. Okay, I just wanted to recognize those public servants. Thank you for being present here and participating. Okay, so seeing as though yes,
Mr. Gould, we did receive. Should we make mention how we did receive a couple letters regarding opposing this?
Yes. So there were also written submissions. You know, there were things both submitted prior to this meeting. There's also time still. That's part of what I just wanted to say in conclusion, that between now and next Wednesday evening at 6 p.m. Next Wednesday evening, we will deliberate these matters. If we have further questions for any of the parties, we can also ask those. There might be time for some additional testimony, but typically any testimony between now and next week you can either call, email, write into our board secretary, Vanessa Adorno, to share anything that you'd like to. Otherwise, I think that we can conclude this matter for tonight and reconvene next week. Anyone have any on the board, or Mike Yakum or Vanessa, any other issues, or can we look for, is there a motion on the floor to adjourn?
We don't have anything else.
Okay.
Walter Gould, I make a motion to adjourn.
Okay, I have
Second.
and so a motion by Walter Gould to adjourn tonight's meeting, seconded by, was that Mr. Corbin?
Yes, yes.
Okay, seconded by Mr. Corbin. We'll take a roll call vote on that. So please say aye or nay. Mr. Corbin,
Yes.
Mr. Gould,
Yes.
Mr. Roldan, Mr. Roldan, could you unmute? Did we lose Mr. Roldan? Oh, there we go. So Mr. Roldan, we're just voting. We have a motion on the floor to adjourn tonight's meeting. How do you vote? Oh, I think we lost him again.
Yeah. No, I vote yes.
Okay, and then
Smart.
finally, Mr. Bruce? Mr. Bruce, how do you vote to yes or no to adjourn the meeting? Mr. Bruce, okay, I would vote in favor.
Mr. Bruce is there, but I don't think he
Okay.
can unmute.
Regardless, I would vote in favor. So we do have a majority vote to adjourn tonight's meeting. With that, we'll adjourn and we'll reconvene next Wednesday night at 6 p.m.